If you're an injured worker and you disagree with an action taken by the Department of Labor and Industries or by a self-insured employer, you're allowed to protest to the Department of Labor and Industries in writing. It always has to be in writing. Or you're allowed to appeal to the Board of Industrial Insurance Appeals. If you've already protested an adverse order once and the department has issued an affirming order saying that it was right the first time it decided the issue, then you must appeal, again in writing, directly to the Board of Industrial Insurance Appeals. So then people call me and they ask me, what's going to happen at the board? And the answer is, the first part of the process is called mediation. What happens is the board will look at the order that has been issued by the department. It'll look at the appeal that has been filed by the injured worker or the injured worker's attorney, and it will approve the fact that a case should go forward at the board. It will accept the appeal as filed. And at that point, the department is placed on notice that the board is going to assume the jurisdiction and decide the issue. And all of the parties, the employer, the department, the injured worker with the injured worker's attorney, all of the parties are invited to a telephone mediation appointment. In that mediation appointment, everybody goes over the jurisdictional history. We stipulate or we make changes to the jurisdictional history so that we can agree that the board has jurisdiction. And then offers are made. One side may offer one resolution, another side may offer a different resolution, and the board has assigned a mediation judge. The mediation judge you might think of as the lowest or most junior judge, but you'd actually be incorrect. They're actually some of the most senior judges at the board. They've had trial experience as judges, running a lot of trials. They know the law very well. And what they can do is they can kind of sit with the parties and say, I think you're weak on this argument. I think you're stronger on this argument. I think if I was listening to this as a trial judge, here's probably where I'd be, and maybe you might want to reconsider, or you're probably going to need to bring more evidence. They give useful information back to the party litigants. And they also try to facilitate the parties getting together with an agreement. If mediation is not successful, the mediation judge will then take the stipulated jurisdictional history and send it to a different judge at the board, which will then be a trial judge. Because the mediation judge has heard things that should not be admissible in evidence, a second judge is used, the trial judge, who will conduct something called a scheduling hearing. At the scheduling hearing, we tell the judge, here's the witnesses we anticipate calling. If we don't know their names, we can say 3 unidentified medical witnesses, an unidentified vocational witness, the claimant, 2 lay witnesses, an employer witness. We can basically put forward the outline of how we're going to present our case. And we decide with the litigation judge, the trial judge, we decide what is a proper statement of the issues that need to be decided. And everybody has input on that. We then pick dates. Those dates are several months into the future. And we then go through pre-trial discovery and motion practices. Eventually, we'll have a trial. And typically, it's the injured worker that bears the burden of proof, because most claims that are, or most appeals that are filed at the Board of Industrial Insurance Appeals are going to be filed by the injured worker. Having the burden of proof means you go first and you must supply a certain quantum of evidence, or your case simply fails. The other side doesn't even have to put on a case. If you meet your burden to put on the kind of evidence that you needed to overturn the department order that is on appeal, then the other side has to go. They have to take their turn. And there may even be a rebuttal opportunity after that, depending on how the facts and the litigation progresses. Once the trial record has been concluded and everybody has gotten to their final date when everything has to be submitted, the trial record closes, and the judge then has 60 days to write a decision. Well, there's no legal requirement that a decision come out within 60 days. There's just a board informal policy that they want the decision to come out within that time period. So now a proposed decision and order is written by the trial judge, and he sends it to the parties, or she sends it to the parties. Each party then has 20 days to protest the decision made by the judge by filing a petition for review. The petition for review must contain all of the arguments, all of the reasons why that aggrieved party believes the board's trial judge got it wrong, and asks for the board's commissioners to look at the record anew and make new findings. Finally, if the board agrees to hear the petition for review, which is a relative rarity, then each party will be able to submit briefing, and the board must issue a final decision within 180 days. But the process doesn't end there, because if you're an aggrieved party, you can still protest, you can still appeal, rather, to the Superior Court. And in Superior Court, you can elect either a bench trial or you can elect a jury trial. If you have not elected a jury trial, the other side can elect a jury trial. And so, as you can see, the process of appeal is quite lengthy, it's quite involved, it's quite technical. You will, in all probability, need an attorney. I've only heard of a few cases where people manage to navigate the system with no attorney. It's not a common thing. Almost everybody who's going to prevail will be represented by counsel. If you have any questions about how the board appeal or the Superior Court appeal or even a Court of Appeals appeal works, please call Washington Law Center and we'll let you know your rights.